Alright, well, I didn't really want to make this, but I'm looking here at this here. Is this a video? This all started with, I saw something where it said, like, it was a meeting where it was like, fun spot, no on 4 or something. I was like, fun spot? I don't know, it was just strange to me. But, unlimited abortion? I don't know. Alright, Alright. Okay. Oh, unlimited abortion. Okay. So let's see. I was saying, why don't you get the damn head person of this, head team of this, in a room with the head team of person and team of this, and get them on a fucking program or something, so that the people in Florida are well informed, you know, and you can see them fact check each other instead of this shit. Because how are you supposed to know? I gotta not curse in this. Unlike other amendments, Amendment 4 does not define any of its key terms. I gotta read it. No law shall prohibit, penalize, delay, or restrict abortion before viability. So what do you want it to look like? You know? Oh, is this the video?
And switch care providers, not doctors, to define health, but never defines. No law shall restrict abortion. 0. This small trick is a big scam. Amendment 4 says no law shall restrict abortion before viability, but
No law shall restrict. No law shall prohibit, penalize, delay, or restrict abortion before viability. I don't even know what the fuck that means. I'm running on like 0.5 brain cells at this point. Restrict abortion before viability. Let me ask you. Let me ask GPT. I don't know what the fuck that means. What does this mean? No law shall prohibit, penalize, delay, or restrict abortion before viability or when necessary to protect the patient's health as determined by the patient's healthcare provider. What does that mean? I don't know. What's before viability?
This statement means that no law should stop, punish, slow down, or limit access to abortion. 1. Before the fetus is viable, meaning able to survive outside the womb, which is generally around 24 weeks of pregnancy. 2. In situations where an abortion is needed to protect the health of the patient, with health being determined by the patient's doctor or healthcare provider. In simple terms, it asserts a legal right to access abortion without interference up until viability or if the patient's health is at risk.
The viability word is throwing me off. What is it saying with that?
Without the word viability, the statement would mean that abortion
No, I
access
didn't say
should
without
not.
the viability word is throwing me off. What does that mean with it?
Viability refers to the stage in pregnancy when a fetus can survive outside the womb, typically around 24 weeks, although it can vary. In the context of abortion laws, viability often marks a legal point where restrictions may begin, as the fetus could potentially live independently with medical support. So when laws mention viability, they're usually setting this point as a boundary, after which abortion might be limited, except in cases where the patient's health is at risk.
Okay. Alright, cool, thank you. Okay, cool. Alright, let's finish this thing here.
Defines viability. It allows late-term abortions for a patient's health, but never defines
Should I just run this thing through the GPT? Whoa. Can you fact check this for me? I'm gonna play you an audio. Can you fact check this for me?
I'm unable to listen to audio directly, but you could type out what you hear, and I'd be happy to help fact check the information for you.
Okay, I'll do that. Are you ready?
Yes, I'm ready whenever you are.
viability. It allows late-term abortions for a patient's health, but never defines patient's health. It allows so-called healthcare providers, not doctors, to define these terms, but never defines healthcare provider, a term broad enough to include non-medical.
This interpretation is largely accurate. In many cases, laws or proposed legislation that protect access to abortion for health reasons leave the term broadly defined, allowing healthcare providers who may not necessarily be doctors to interpret it. The term health can include physical, emotional, psychological, and familial factors, depending on the specific language of the law and how courts have interpreted similar language in past rulings. Similarly, healthcare providers can indeed refer to a range of professionals, not just physicians, depending on how a particular law or policy is written. This could include nurse practitioners, physician assistants, and other licensed practitioners. The exact definitions often depend on state laws or specific guidelines within the legislation.
So it's saying for long-term abortions, you can do that?
Yes,
It
if a
never
law
defines.
permits abortion without restrictions based on health, it can allow for abortions later in pregnancy if a healthcare provider determines it's necessary for the patient's health. Since health isn't always strictly defined, it can include broad considerations, potentially allowing late-term abortions under a range of circumstances, depending on the provider's judgment.
Does that happen a lot?
No, late-term abortions are quite rare. They make up less than 1% of all abortions. When they do happen,
I feel like if you
typically
want to
due
get a
to
fucking
severe
abortion, you get a
medical
fucking
reasons
abortion.
like risks to the mother's life or serious fetal
Or I guess
abnormalities that are often
if you
only
change your mind, I
detected
guess.
later in pregnancy. Most providers follow strict guidelines, so even when laws allow flexibility for health, it doesn't generally lead to an increase in late-term procedures without serious justification.
This video is saying the patient's health could include mental stress. So that's why people are, I guess, they're saying that they're saying, my mental health, I want a late-term abortion, and then they're getting it. Could include it, it's saying.
Patient's health.
Yes,
it allows
you're
so-called
correct in
healthcare
understanding that
providers,
health can
not
include mental
doctors,
health.
to
In
define
some
these
legal
terms,
contexts,
but never
health has been
defines
interpreted
healthcare.
broadly to encompass not just physical health, but also psychological and emotional well-being. This can mean that a patient could potentially seek an abortion later in pregnancy if they feel their mental health is at risk and a healthcare provider agrees that it justifies the procedure. However, it's important to note that late-term abortions for mental health reasons are still very rare and typically involve a detailed medical evaluation. The broader definition of health has sparked debate, but it is not a routine or widespread reason for late-term abortions.
Okay. And then, so this is all related to the Amendment of 4. And so it's also saying that healthcare provider can mean that it's not a doctor to determine this.
Yes, that's correct. The term healthcare provider can be broader than just a doctor, depending on the legal language. It could include professionals like nurse practitioners, physician assistants, or other licensed healthcare workers. This means that in some laws or proposals, these providers, not just doctors, could be the ones to determine if an abortion is necessary for the patient's health, which might include mental health concerns. The expansion of who can make these decisions rather than restricting it to doctors is one of the points often discussed in legal debates surrounding abortion laws.
And this is for late-term abortions. That's what this video appears to say, is that it's for late-term abortion.
Yes, based on the context you're describing, the video seems to be referring to how the broad definitions of health and healthcare provider could apply to late-term abortions. If a law allows abortions for health reasons, and health includes mental or emotional well-being, then a healthcare provider, which may not necessarily be a doctor, could determine that a late-term abortion is necessary. While this does indeed apply to later stages of pregnancy, such cases are still rare and would typically require a thorough evaluation to ensure it meets legal and medical standards. The video likely emphasizes that the flexibility in definitions could potentially lead to broader access to late-term abortions, though such procedures are still uncommon and usually only considered for serious health reasons.
Alright, I'm going to play the rest of the video, okay?
Sure, go ahead. You can type out what you hear, and I'll help you with it.
A term broad enough to include non-medical staff at abortion clinics. Just as bad, Amendment 4 eliminates Florida's parental consent laws, replacing consent with notification, and making abortion the only medical procedure a minor could undergo without a parent's consent. They didn't have to write Amendment 4 this way, but they did. Why? Because they want to deceive you, to make their extreme amendment seem reasonable. This is what Amendment 4's ballot summary says, but this is what it means. No law shall prohibit any abortion at any time for any reason determined by abortion clinic employees. This amendment makes abortion the only medical procedure your child can undergo without your consent. It sounds extreme, because it is extreme. No definitions, no doctors, no parental consent. Amendment 4, way too extreme, and not what it seems.
The claims in the video you're referencing seem to be a critical interpretation of Amendment 4, focusing on the potential implications of broad language and its impact on minors. The video suggests that the amendment could, 1, expand the definition of healthcare provider. The claim here is that the amendment could allow non-medical staff, like those working in abortion clinics, to make abortion decisions which would not necessarily require a licensed doctor. This is a concern some have about the amendment's language, but the specifics depend on how the law is written and implemented. 2, change parental consent laws. The video argues that Amendment 4 could replace parental consent for minors seeking an abortion with just parental notification. This is a critical issue, as parental consent laws in many states require a parent's approval before a minor can have an abortion. If only notification were required, as the video suggests, it would indeed be a significant change. 3, deceptive framing. The video contends that the amendment could be written to appear more reasonable than it is, by omitting certain details that could make it seem more extreme. It's important to note that the exact details of Amendment 4 would depend on its full legal language and how it's interpreted in practice. While the video presents a particular view, legal experts and advocates might offer different interpretations of how this amendment would function in reality. reality.
So is the video right? I guess is there more, is there like a detailed version of Amendment 4?
Amendment 4, which will appear on Florida's ballot, aims to make abortion a constitutional right in the state. If passed, it would prevent any laws from prohibiting, penalizing, delaying, or restricting abortions before a fetus reaches viability or when necessary to protect the patient's health as determined by their healthcare provider. The term viability is legally defined in Florida as the stage of fetal development when a fetus can survive outside the womb with standard medical measures, generally considered to be around 24 weeks. The amendment is controversial, with opponents arguing that the term viability is too vague and could lead to broader access to abortion. They also object to the clause allowing healthcare providers to determine the necessity of an abortion. If passed, the amendment would remove any legislative bans on abortion in the state. For further details, you can read more from Health News Florida.
All right, let's go on yes on 4. Let's see what they're up to. How about that? I don't want you to look.
Florida's Amendment 4, which will appear on the November...
I'm gonna play you their video, is what I mean.
Sure. Go ahead with the video. Let me know when you're ready, and I'll assist with any questions afterward.
Florida has a near total abortion ban, with no real exceptions for rape, incest, or the health of the woman. It bans abortion before many women even realize they are pregnant. The only way to stop the ban is to vote yes on 4. Amendment 4 is simple. It will protect the right to abortion in the Florida Constitution. Florida women should have the right to make their own healthcare decisions in consultation with their doctors and those they trust. Vote yes to give Florida women their rights back.
The video you played highlights the argument for Amendment 4, which aims to protect abortion rights in Florida, particularly in response to the state's near total abortion.
The abortion rights movement
seeks to secure a
in Florida,
constitutional right to abortion before viability or when necessary to protect the health of the patient, including circumstances involving rape, incest, and health risks. Florida's current abortion restrictions are among the most stringent in the U.S. The law bans most abortions after 6 weeks of pregnancy, which is before many women even realize they're pregnant, and does not provide exceptions for cases of rape or incest.
Are you passionate about auto repeal? At Universal Technical Institute, you can train hands-on and learn skills that employers need
to make reproductive health care decisions in consultation with medical professionals and others they trust. The amendment focuses on protecting reproductive rights by allowing voters to enshrine these rights into the state constitution, offering an alternative to the state's current restrictive laws.
Oh, here, they don't have a video, but they have a page, so I'll just read the page, okay?
Go ahead and read the page, and let me know what you'd like to discuss or clarify. I'm here to help as you go through it.
So with the no law shall prohibit, penalize, or delay, it says this ends Florida's extreme abortion ban, saving women's lives and health and getting government out of our exam rooms and medical decisions. As far as it says with the patient's healthcare provider, which seemed to be a big thing, it says gives women and doctors the freedom to make healthcare decisions. So I guess that's a little misleading, maybe. And then it says maintains existing parental evidence. Okay, so then it says to require notification. To that point, it says maintains existing parental rights, right protections in Florida's constitutions. Let me see if there's a... This one says, does this initiative allow people who aren't doctors to provide an abortion? It says no, it ends Florida's extreme abortion ban. Healthcare providers must be licensed to provide healthcare. Healthcare provider is used throughout Florida's law. They are regulated by the state and must follow medical ethics. So they're saying that... So this is very confusing. So what do you think about that one?
The page you're reading seems to be providing arguments in favor of Florida's Amendment 4, but there are a few key aspects that are important to break down. 1. No law shall prohibit, penalize, or delay. This phrase is part of the amendment's language that ensures access to abortion before viability or when necessary to protect the patient's health. The wording might feel broad, which can lead to confusion. The goal is to provide protection from restrictive laws, but it does leave flexibility for interpretation, particularly around what constitutes health and who determines it. 2. Patient's healthcare provider. The amendment allows healthcare providers to make decisions about abortion access. But the question here is, who qualifies as a healthcare provider? While the amendment states that healthcare providers must be licensed and regulated by the state, the term healthcare provider is broader than just doctors. This has been a point of contention, as it could potentially allow non-physicians to be involved in the decision-making process, which some people find concerning, but others argue that it ensures more access to care. According to the supporters of Amendment 4, these providers would still be regulated and must follow medical ethics. 3. Parental notification. The amendment states that it maintains existing parental notification requirements for minors. This seems to reassure critics who are concerned that minors could access abortion services without any oversight from parents. The wording here is important. Notification is different from consent, and the amendment only requires informing parents, not obtaining consent for an abortion. 4. License and regulation. The amendment asserts that healthcare providers, whether doctors or other licensed professionals, must follow medical ethics and are regulated by the state. However, as you noted, there is some ambiguity here about who exactly qualifies as a healthcare provider, which could include non-doctors depending on how it's interpreted. Critics worry that this could mean that non-physicians could be making decisions about abortion access, which could lead to debates about the level of expertise required for such procedures. In summary, the language used in the amendment leaves room for interpretation, especially regarding healthcare providers and their role in decision-making. Supporters of the amendment argue that it ensures access to abortion and protects women's health, while critics are concerned about the broader definition of who can provide an abortion and the potential lack of clarity on when health exceptions apply.
So,
it sounds like the page is presenting arguments in favor of Amendment 4 while addressing some of the concerns raised by critics. 1. Patient's healthcare provider. The amendment allows a broader group of licensed healthcare providers, not just doctors, to determine abortion eligibility. This is based on the idea that healthcare professionals can make decisions in consultation with the patient, allowing for more accessible care. However, as you noted, some worry that the term healthcare provider could include professionals who are not doctors. The amendment maintains that these providers must follow state regulations and medical ethics. Critics are concerned that this could open the door to non-physician providers performing abortions or making decisions that could potentially raise concerns about the level of expertise involved. 2. Parental notification. The amendment does maintain parental notification for minors, which could be seen as addressing concerns that minors might undergo abortions without parental knowledge. However, this requires notification, not consent, which is different from what some might expect. So, while it doesn't eliminate parental involvement, it modifies the level of control that parents might have over a minor's decision. The term healthcare provider is likely the key point of contention in how this amendment is interpreted. Supporters argue that it ensures access to care and puts decision-making in the hands of qualified professionals. Critics worry about the potential for non-physician involvement and whether that could impact the quality of care.
Okay. So basically, whoever wrote this amendment dropped the ball because it says patient's healthcare provider? Because is that kind of the center here? I mean, I guess the notification is a big piece of it, but I feel like the patient's healthcare provider, I feel like is contentious between both like pages. So, with that said, do you also think that it's the specific, like it's the specific amendment that kind of like the wording and not the like? Does that make sense?
Yes, the phrase patient's healthcare provider in the amendment is indeed a central and contentious point. The issue arises from the ambiguity of the term healthcare provider, which could potentially include a wide range of licensed professionals, not necessarily doctors. This broad definition opens the door for debate about who gets to make the crucial decision about whether an abortion is performed, especially as some worry that non-physicians could have a role in decisions about abortion procedures. This can be a significant concern for critics who believe that only physicians should make such medical decisions due to their level of training and expertise. The language could have been more specific to avoid such ambiguity and to reassure people that only doctors would have the authority in these situations. In contrast, supporters of the amendment argue that expanding the scope of who can make these decisions ensures greater access to abortion services, which they see as a necessary step for protecting reproductive rights. They emphasize that healthcare providers, regardless of their specific role, must still adhere to state regulations and medical ethics, which are designed to ensure patient safety and care. The parental notification requirement, as you've noted, is another part of the amendment that's likely to be contentious. While it doesn't eliminate parental involvement, it modifies it by changing consent to notification, which is a significant shift that impacts how much control parents may have in the decision-making process for minors seeking an abortion. Regarding the wording of the amendment itself, it does leave room for varied interpretations, and that vagueness contributes to differing opinions on its potential impact. A more precise definition of healthcare provider and clearer language regarding who can make decisions would likely have addressed some of these concerns. This type of ambiguity is often the focal point of debates over legal texts, especially in sensitive areas like healthcare and reproductive rights.
Okay. The notification thing I think is fine. I think the parental consent thing is a little too much. Because then what if you get a situation where they're like, you're going to have this rape baby or, it's a little extreme, but you're going to have this baby if you want it or not, or this sort of thing. And then there's the complications, right? I'm reading the current 2023 law I guess, here. But yeah. Where's the middle, GPT? Where's the middle? Can you find the middle? Can you find the middle here?
Finding a middle ground on this issue can be tricky because the debate over abortion rights often involves deeply held personal beliefs about bodily autonomy, parental rights, and healthcare access. However, a balanced approach might look something like this. 1. Parental rights and minors. Instead of a strict parental consent requirement, which can create significant barriers for minors in certain situations, such as cases of rape or incest, a judicial bypass system could be used. This allows a minor to go to a judge to seek permission for an abortion without parental consent if they feel that informing their parents could put them at risk or cause harm. This ensures parental involvement in a way that respects the minor's safety and circumstances while still preserving a degree of parental authority. 2. Healthcare providers. The definition of healthcare provider could be narrowed to ensure that only licensed medical professionals with appropriate qualifications, such as doctors, nurse practitioners, or physician assistants, are making decisions about abortions. This would address concerns about non-medical staff being involved in making critical health decisions while still allowing for some flexibility in who can provide the service. This way, the focus is on qualified individuals making these decisions, which could help to alleviate concerns about safety and expertise. 3. Abortion access. On the issue of timing, an approach that allows abortion up to the point of viability, with exceptions for the health of the mother, including mental health, may strike a balance. This recognizes the importance of the mother's health and well-being, which can include mental health considerations, but also places a reasonable limit on when an abortion can occur. This approach could limit late-term abortions to cases where there are serious medical concerns. 4. Informed consent. It's essential that any decision, whether it involves abortion or other medical procedures, is made with the patient's informed consent. This means ensuring that patients fully understand their options, the potential risks, and the consequences of their decisions, with guidance from healthcare professionals. Finding the middle ground involves creating a system that respects both the rights of individuals seeking abortions and the legitimate concerns about parental involvement and medical safety. This would likely involve specific legal frameworks that address each of these areas while trying to ensure fair and equitable access to healthcare.
Alright, can you rework the first one? I feel like time's of the essence here. Not trying to make a pun, but like literally, so like, can you rework maybe the first one here?
Here's a reworked version of the first point with a focus on urgency and clarity. Instead of requiring parental consent for minors seeking an abortion, which can be a barrier in cases of abuse or extreme situations like rape, the law could implement a judicial bypass system. This would allow minors to petition a judge for approval, ensuring their safety and autonomy while maintaining parental rights.
I know, but like something different besides a judge. That's what I mean. With the time and stuff like that.
Here's an alternative suggestion for addressing the issue of parental consent for minors without involving a judge, especially in urgent cases. In situations where a minor needs an abortion but is unable to get parental consent, a licensed healthcare provider could be empowered to assess the circumstances and make a decision based on the minor's health, safety, and emotional well-being.
Or you just let them get the damn abortion.
If we focus on the urgency of the situation, one perspective is to allow minors to access abortion services directly without parental consent.
I'm for that one.
As long as they are
Let them
able
have
to
the
make
fucking
an
abortion if they want to have the
decision about
fucking
their
goddamn
health.
abortion.
In cases where a minor is at risk or in crisis,
Their fucking
such
body.
as from sexual abuse or other harmful situations, it would be crucial to prioritize their safety and autonomy. Removing parental consent requirements could help ensure that time-sensitive decisions are not delayed due to barriers like fear of backlash or physical safety concerns. Some advocates argue that this approach is necessary to protect the rights and well-being of the minor, especially in scenarios where involving parents may not be safe or feasible. Of course, safeguards would be needed to ensure the process is not abused, but ultimately, the idea is to ensure that the minor has timely access to care without unnecessary hurdles that could put their health at risk.
Okay. Cool. All right. Thanks, GPT. Very, very helpful.
You're welcome. I'm glad I could help clarify things for you. If you ever need more assistance, don't hesitate to ask.
All right. Drinking fucking aloe mango juice. Let them have the fucking goddamn abortion. Let them have it. It's her fucking body. And then you get into a whole other slew of things, huh? You're like, what if they're not thinking straight? You know, what if they're just not thinking straight? They're not thinking it all the way through. So what do you want to do? You want to convince the human being that it's wrong, and then they go, oh, okay, I guess I'll have the baby. But, yeah. It's a tough one. Not gonna lie. It's a tough one. I think ultimately it's better to let them have the choice. And if the concern is that, well, they're just not in the right mindset, see if they think about it this way. I'm not talking about that. I think it's better to let them have the baby how they want to have the baby. That's what I think. So then you get, well, maybe there's a crazy person that wants to have an abortion. Well, you let the crazy person have the fucking abortion. That's what I think. Alright. Shitty amendment. I do like the bottom piece of require notification, so I do like pieces of it. Alright, let me get over here.